Good morning, Mr. Venable.
Yes, sir.
Mr. Venable, you're charged with 2 counts of assault. One is of a family member. On both of those, you're facing up to
Okay, pause here. Notice how the judge immediately lays out the maximum penalties. This isn't just for show, it's a tactic to remind the defendant of the gravity of the charges. Quick question for you. Do you think starting this way helps scare defendants straight, or does it just set the mood for the hearing?
a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, Ms.
On January 21st of 2024 in Harris County, Texas, officers were dispatched to an AFM call. Officer met with the complainant. The complainant and the defendant have been dating for 5 months. The complainant and the defendant were arguing. The defendant pushed the complainant to—
What did you catch that? The officer reported the defendant stepped on the complainant's neck, but because there wasn't evidence of breathing problems, prosecutors didn't charge it as strangulation. That's huge, because strangulation often upgrades a misdemeanor assault into a felony. What do you think? Should stepping on someone's neck automatically count as strangulation, or do we need proof of breathing issues?
to the ground, causing her to scrape her right arm. While the complainant was still on the floor, the defendant stepped on her neck. Officer noted—
Stepped on her neck?
Yes, Judge. Officer noted redness on the complainant's arm and neck.
You know if it impeded breathing?
No, Judge. I don't, I can't, let me check. It wasn't charged as an impeding breath, so—
Well, I know it wasn't charged, but is it?
The DIMS don't say that she had any trouble breathing, but I'll look at the offense report, Judge.
And here's the other thing. The first assault is from October of 23. The second assault is from January of this year.
Yes,
And now we have a felony evading arrest on December 10th.
yes, Judge.
Were these 2Bs? Was he out on bond for these? Vic, do you know?
It looks like— No,
So
it
this is
looks-
Venable, who's now picked up a third case. He had 2 misdemeanors, one's from 23, one's from 24. Did we ever do PC, or had he ever been on bond
No, Judge, it was just a non-arrival.
for the whole time? All right.
Judge, it doesn't say that she had trouble breathing, it just says that it caused her pain.
Okay, can you do probable cause? So that's the family member, right?
That's the AFM,
Okay,
Judge.
can you do the first case? Because I don't think we've done probable cause on that one though.
This is the AFM from January 21st. Oh, the ABI, the one before.
Yeah, the one before.
On 9/29/2023, officers were dispatched. On arrival, officers spoke with the witness.
This is the judge's big moment, laying down the hammer. Notice the tone shift here. It's less about the facts of the case and more about community safety and control. Judges often use this type of language to justify strict bond conditions. But do you think tough warnings like this actually stop repeat offenders, or is it just courtroom theater?
Complainant's wife, who said that the defendant assaulted the complainant by slapping him in the face because the complainant's dog killed the defendant's girlfriend's cat. Then officers spoke with the complainant, who said he had invited the defendant into his residence to discuss the situation when the defendant said she should knock the shit out of him. And the next thing complainant knew, the defendant had struck him across the left side of his face with his hand, causing pain.
Mr. Venable, I want you to understand one thing, that I'm going to do everything in my power to protect my community at all costs.
Sure.
And if that means I have to make your bond extremely high, taking you into custody, kicking and screaming, I'll do it in a heartbeat. Do you understand?
Sure.
I'm ordering you as a condition. I'm going to find probable cause on both of your cases, and I'm ordering you not to have any contact with either of the people in this case.
Sure.
There's a protective order that has been issued in the family case. I would get to know it. Don't say anything. You will get the opportunity. Now is not that time. I'm telling you what the expectation is while these cases are open, and what the expectation is for you to be able to live in this free world. because if you don't abide by these expectations, I'm going to take the free world away from you. You are not to consume alcohol or illegal drugs, and I'm going to randomly test you. You're also not to have contact with either of these people, not to be in possession of any weapons, and abide by the conditions of the protective order. If you violate those conditions of the protective order, the state can file a fourth case, a violation of a protective order. If they do, that is the capital murder of misdemeanors. It's one of the worst cases you can pick up, and you violate those conditions, I can have a hearing to hold you at zero bond. Zero bond, and I'll do it in a heartbeat to protect every person. Do you understand?
Yes, sir. Yes, Your Honor.
Do you have a Texas driver license?
I do, but it's
So you do not have a Texas driver license. I am now ordering you also as a condition of your bond not to drive. You will be signing an affidavit with me today promising you that you're not going to drive. I don't care what's going on in your life. I don't care what you got to do. I don't care where you got to go. You violate this, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car.
an Ubering to and from, so.
Don't. There's nothing you can say to justify. I'm not asking you. I'm telling you what the expectation is.
Yes, Your Honor.
We are now going to reset your case to give you time to hire a lawyer. So for now, I'm going to have you come up here, sign this order, promising us you're not going to drive. I will get you to Victoria, where we will have you sign a reset for you to go get a lawyer. You will meet with Felicia for your bond conditions, and after that, you'll be free to go.
Sir.
The one in there that has contact.
Got it. Okay. So Rosette, the order in the one that's signed by the magistrate is allowing contact, but I'm going to issue one now so that he can have contact. Okay? Just so that you know.
Also, I don't see a motive on the assault bodily injury case.
Well, it's because it's not a family member case. That's why. You can only do it on the family member cases. All right? That way. John D. Hey, bud.
Judge, was that CHA?
Sorry, I'm on.
Be like Victoria Venable. Okay, thank you.
John D.
Judge,
What's the word?
I'm gonna put first on young Mr. Cuellar, Diego Cuellar. He's due back today because he wanted some proof that he's getting his GED. I spoke to him this morning. He had to get an ID in order for him to get his high
I
school.
think he's supposed to come here with his ID today, wasn't he?
Yeah, he showed me a proof that he's applying for it. He hasn't gotten the ID.
Come up.
And he's got proof on his phone that he's been researching the GED program. So he's taken active steps towards it, Judge. He just doesn't have the ID in order for him to get the transcript. So
Mr.
that he
Bear, you haven't done
officially in the
absolutely.
GED program. Right?
I have to wait for the school to mail in the transcript so I can get the ID. They said I need my old school record so they have proof of who I am. But I have my GED login on my phone. I can show you.
To go get an ID, all you have to do is go to DPS and get an ID, right?
If they're under the age, they actually have to have a student verification form from a school.
That's what he's waiting for.
I was there
He's got
yesterday.
he's got,
What school is this?
Calhoun High School in Port Lavaca. Calhoun High School in Port Lavaca. I called them yesterday. They're gonna mail it.
The day before court, you call,
That was when I had my appointment for the DPS.
okay? So how long are we gonna wait for you to get the ID to be able to start on your GED?
Well, they said they mailed it already, so probably it's like a couple of days, like 3 days.
So let's set it a week. Okay, all right, I'll see you in a week, sir. All right,
okay, go ahead. Go ahead. I'll-
Judge,
I'll-
was
I'll
that
text you.
Cuellar?
yeah,
Yes, that was Cuellar.
okay, John D,
Did you
who's
get the
next?
results for his stress test?
Well, you sent.
Second, I'll check.
You sent him to get tested last time, but it hasn't been 30 days, Judge, because you wanted him to come back to show proof. So
That's all right, John.
So I think by next time, he told me it's clearing out. So that's good. The next one I have, Judge, is, well, we have to approach on Mr. Yeah,
Yeah.
Imamovich, Judge. They're gonna
With an
file
I?
with an I-M-A.
Whether you're dismissing it?
Yes, there.
Yes, Judge. So I think, so we had dismissed the ABI, but I don't think we ever got the MOA dismissed. And so he got picked up on a VPO.
So,
But we don't plan on moving forward with the
Okay,
VPO.
all right, I'll sign it.
got it, Judge.
Thank you,
And then
Judge.
lastly, I have Mr. Johnson, but they
So
are,
there's the proof. You see that?
well, hey,
Even if the case gets dismissed, the DPO still lives on.
there you go, Judge. But it's good news, right things being
Yeah,
done.
you're doing it right.
Mr. Johnson, they are seeking some chief discussion in order to get that off your docket
The
today.
case
I'm
is
just
not
waiting.
over.
No, I got you, but I just want to give you an update on it.
Might-
It might be off your docket today. 'cause